All rise.
The Kosovo Specialist Chambers is now in session.
Please be seated. Mr. Court Officer, please call the case.
Your Honors, this is file number KSC BC 2020-07, the Specialist Prosecutor versus Hisni Gucati and Gucati&Haradinaj.
Thank you. I see no material change in the composition. Do you have a change, Mr. Cadman?
One addition this morning, Mr. Jonathan Warboys is joining Mr. Haradinaj's team.
All right, thank you. And I do notice, for the record, that Mr. Gucati and Mr. Haradinaj are present in the courtroom. Yesterday, the SPO finished their direct examination of Ms. Pumper, and the defense has started its cross-examination. Now, before we bring back the witness, the panel will address some preliminary matters. First, in relation to the so-called associated exhibits, the panel notes that the prosecution filed in F367 two lists of exhibits that it links to the witnesses' declarations on 29 October 2020 and 17 February 2021. These two lists are now marked as P127 MFI. The panel first notes that Rule 154 of the rules concerns admission of written statements or transcripts of evidence of a witness and not exhibits associated with statements or transcripts. The panel prefers to verify the admissibility of each of the associated exhibits before deciding on whether to admit them. It is also noted that two of these exhibits have already been admitted as P57 and P124, and an excerpt of another exhibit was admitted as P125. Another exhibit has been marked for identification as P99 MFI. The SPO used some of the other exhibits or their excerpts with the witness without requesting their admission at that time. The panel understands that the SPO did so on the assumption that there was a standing request to tender all of those associated exhibits. The SPO has made no legal submissions to support its view that associated exhibits are admissible under Rule 154. For purposes of clarity, the panel orders that the SPO to file by Monday, 25 October, a table listing the exhibits or MFI number, if one has been assigned, or the ERN, if no number or MFI number has been assigned, of the associated exhibits that the SPO seeks to have admitted through witness Pumper. The SPO shall identify whether each such exhibit or part thereof was shown to the witness during her evidence. The SPO shall file with that list a brief legal submission outlining the rule or rules which govern the admissibility of those exhibits. The panel orders the defense to indicate orally or in writing which of those exhibits it objects to by close of cross-examination, and that concludes the notice of the associated exhibits. I might add that we re-emphasize the fact that was stated in our order for the conduct of the proceedings, that we use the P number or the P number MFI on any document that has that indication. It makes it much easier for everybody. Now, preliminary matters concerning cross-examination. First, the panel notes that only one defense queue of cross-examination documents has been released. I checked with Mr. Haradinaj defense whether this means that they are not planning to cross-examine Ms. Pumper or that they intend to stand by one cross-examination handled by Mr. Reese, or if they intend to rely on the same set of documents as released by the Gucati defense. Mr. Cadman.
Thank you, Your Honour. Having discussed it with CMU this morning, we are just notifying the court that we will be accessing the same presentation queue that the defence for Mr. Gucati has.
So no new possible exhibits. Thank you very much. Secondly, I promised Mr. Reese yesterday that the panel will confer regarding the parameters of cross-examination on some of the matters touched upon yesterday. So here is the panel's oral order. The defense may ask questions to the witness about her knowledge on whether any current or former member of the SPO or any private party acting under the instructions or control of the SPO delivered or provided material in question to the War Veterans Association. So general questions about Ms. Pumper's knowledge regarding any involvement of the SPO staff in the delivery of the materials or steps taken by the SPO to investigate the entrapment allegations may be asked. However, these questions cannot turn into a fishing expedition regarding the SPO's general investigation on the provenance and delivery of the batches. Also, cross-examination involves putting questions to the witness in respect of what the witness knows about a particular matter. It is not a means to circumvent rules on disclosure or investigation. Therefore, the defense will not be permitted to ask Ms. Pumper in relation to the matter to conduct further investigation or review of documents on its own behalf or on its behalf. It is for the defense to conduct its own investigation and, as the case may be, to make disclosure requests to the prosecution of information thought relevant to the case. Furthermore, questioning on these matters may be stopped by the panel if it goes into the area covered by the ongoing Rule 102.3 litigation. The panel recalls the indication it gave on 18 October that, quote, should any of the material concerned by the Rule 102.3 applications be subject to a disclosure order, the defense could request that either or both witnesses be recalled for further cross-examination in relation to that material. Should the panel have to stop cross-examination on that basis, it might revisit its position and offer counterbalancing measures at a later stage once the issue of the pending 102.3 applications has been fully elucidated. This concludes the oral order on the parameters of cross-examination. The panel further notes an issue that came up regarding the tab numbers used with Ms. Pumper to direct her to a specific item. The panel found it difficult to follow these directions as it does not have the same tab numbers. We understand that the SPO also provided on each occasion the ERN number, but for the examination of all future witnesses, the panel prefers that the tab number coincides with the item number on the exhibit list. Also, the panel reminds the parties of its direction in the order on the conduct of proceedings to use the assigned exhibit numbers. Please keep this in mind in relation to MFI exhibits. Once they are assigned a number, please use it when referring to that exhibit. That concludes the notice on tab numbers. In addition, in response to Mr. Cadman's comment about the SPO's use of private sessions yesterday, the panel agrees with you, Mr. Cadman, that the prosecutor could have made more limited use of private sessions by organizing its questions differently. However, in the circumstances and in the light of the fact that this did not cause prejudice and was only limited in scope, the panel will refrain for this one time to order the reclassification of this part of the transcript. The panel directs the parties, however, to organize their questioning in such a manner as to limit the need for private and closed session to the maximum extent possible. This concludes the notice on the use of the private and closed sessions by the parties.
Right, just briefly,
Yes.
can I say this? Obviously, the trial panel has given some detailed guidance there in relation to the parameters of cross-examination, and also reminded quite properly the parties to use the P numbers or MFI numbers. can I ask for the panel's indulgence during the course of today? If I stray outside those parameters, no doubt the trial panel will stop me, but there's no discourtesy intended because, of course, I've prepared my cross-examination without the assistance of that oral order. And likewise, I've prepared my cross-examination by reference to the ERN numbers, which were being used by the prosecution during the course of direct examination. So again, no discourtesy intended. And if there is any difficulty that arises, perhaps if I could be allowed an opportunity to reflect on it. But I hope that if we can proceed, the trial panel can then intervene as and when necessary.
Just don't stray too far.
I will do my best.
All right.
I'll do
All
my
right,
best, John.
We'll be watching. You can call in the witness at this time.
Thank you. Good morning.
Before we continue with Ms. Pumper, I just want to put on the record that upon her request, parts of yesterday's transcript containing Mr. Rees' questions regarding persons in charge of the SBO investigation were provided to the witness. Mr. Rees, you may have the floor.
For you to settle there. So we'll begin today, I think, with the declaration that you made, which is ERN 084015 to 084026. And the first page of that declaration, please, Mr. Court Officer. And if we can adjust the height to fit the screen, please. Thank you. And just in general, Mr. Court Officer, if we can adjust it so that we can see the full page, because although there are some pages where obviously that there are parts of the text more important than others, there are other documents where we will look very closely at both the top and the bottom of the page. So this is the first page of your declaration, beginning ERN 084015. And Ms. Pumper, you also have a document that a version of this that you annotated with some red notes. Is that right?
That is correct.
So, Ms. Pumper, can I ask if you have your annotated version available to you as well, please?
Yes, I do.
Now, you have set out, paragraph 2 of that declaration, some background into your experience, and you have gone through that orally with us also. And at paragraph 3, you identify that your duties include, among other tasks, analysing and reporting on evidence. And part of your tasks involved in this case have been preparing an analysis, have they not, on batches 1, 2, and 3 as you have described them?
That is correct.
In paragraph 4, you said in preparing this declaration, you reviewed SPO documents and correspondence and obtained information from colleagues within the SPO. Can I ask you this? Did you make any contemporaneous notes while you were undertaking your review?
Yes, I did.
And where are those?
In the office.
The notes that you made on this declaration, as you described it, the annotated declaration, when did you make those red notes?
I made them in preparation for my testimony.
So when was that?
I believe maybe 2 weeks before my first day of testifying, I started doing that, making
So
these notes.
the beginning of October?
It was like a couple of weeks before, I believe.
A couple of weeks before the beginning of October?
Before my testimony.
Okay, so are we talking about the first week of October?
I'm sorry, I cannot recall because I took 2 weeks leave. So I believe that after that I started making these specific notes. But if not that week, it was the week before I took my 2 weeks leave.
And did you prepare the annotated version of this declaration in late September, early October, at the request of any specific individual? Were you asked to make an annotated declaration?
No, I was not.
And did you have your contemporaneous notes to hand while you made the annotated declaration?
Yes, I did.
Do those notes set out the information from colleagues that you obtained and used in the course of your analysis?
No, they do not.
Did they identify which colleagues you spoke to?
No, they do not.
Did you record anywhere the information that you obtained from colleagues that you used in your analysis?
I relied on the official note and in passing asked clarifying questions, but the questions I did not document.
So you relied on some conversation with colleagues.
Yeah,
Did you make any note of that conversation?
I did not.
Can you say now what conversation from colleagues you relied on when preparing your analysis?
The conversations with my colleagues were very limited. I believe that I asked one officer in relation to batch 1 seizure, and then I asked the investigator in relation to the seizure of batch 2 and batch 3.
You say in the annotated version of paragraph 4 that you reviewed the batches and media publications, but you also accessed Xylab, DT, CaseMap, and GWL. What is Xylab, please?
Xylab is our database in which our evidence is contained. Any document which we provide here and submit into evidence is there.
So it's a document that is identified as having some evidential worth, which is submitted to Xylab and given an ERN.
Yes, I think so.
And that process involves submission to the Case and Evidence Management Unit?
Yes, it does.
And once that document is provided to the Case and Evidence Management Unit, the process of scanning the document, attributing the ERN is a matter for CMU, as it's known by its acronym.
That is correct.
What is DT, please?
DT is also a database which we have, which searches of the internal system can be conducted. That is in addition to Xylab.
What does DT stand for?
Actually, that is a good question. I don't know.
Right. And so Xylab for evidence, DT a separate system, and what is the criteria for submission of a document to DT then?
In the DT, there is the folder system. So we have a folder system where you have drafts, where you have work in progress. In the DT, you will find documents which do not bear an ERN number.
Case map? What is case map, please?
Case map also contains evidence which contains material which has been ERN'd. There are two databases which we work with. Evidence is in case map as well as in Xylab.
So what is the purpose of Xylab and what is the purpose of case map?
If I can explain that, in case map I access the global witness list, and the purpose of that is that we register witnesses and give them an individual number. That is what I accessed in case map, but the main review other than that was in Xylab.
I follow that, and we will come on to the methodology of your specific analysis of the batches. But just so we have an overall understanding of the way in which the SPO processes information, which the relevance will become clear if it's not clear already. What is the distinction between Xylab and CaseMap? Why would you use Xylab, and why would you use CaseMap if they both record evidence?
To be clear, I don't know why we have two systems. I know that we have two systems, and I search both systems.
What about GWL?
That is the acronym for Global Witness List.
And that is to be found in CaseMap, is it?
Yes.
Not in Xylab?
No.
And the Global Witness List, that accordingly would not have an ERN?
No, that is a system where we register.
Yeah. So that wouldn't have an ERM, and
No.
the information in it wouldn't.
No.
Can I ask you about some of the ERNs? We know from the material that Ms. Bellici has taken you through that the majority of ERNs consist of a straightforward number with no letters. So, for example, we have seen the SPO delivery document relating to documents seized from the KLA WVA on the 8th of September 2020, and that has an ERN 080-449-080449. Some documents that we've looked at, however, have a reference number that begins SPOE. What is the distinction?
To my understanding, it is if you do not have a SPOE or a SITF, the letters before are just a number, these documents have been manually stamped when they were submitted, as opposed to when you have a combination letters and numbers, these documents have been stamped electronically.
So where we see SPOE, the reference number is applied electronically to the document.
That is my understanding.
Is that when the document, if it's a hard copy document, is scanned into the system?
Can I put it this way? If I submit an official note in hard copy with my submission, it will be stamped manually and it won't have letters. If I submit any evidence, an official note with a DVD, that DVD, the contents of this DVD will be electronically stamped and it will have an SITF number. So if the CMU, which I'm not privy to, I assume if they scan something, maybe they didn't stamp it manually, or they stamp it manually before and then they upload it in the database and then you can see the abbreviation without letters. But if they upload it electronically, it will be provided the year and with letters, and that is the electronically stamped, if that makes sense.
And the difference between the SPOE numbers and the SITF numbers, what does that indicate to us, if anything?
For me, that indicates, or that says that the SITF numbers, they were stamped during the period of the SITF, and the SPOE were stamped during the period of the SPO.
Does the indication of SITF at the start of the number indicate that the SITF electronically stamped the document or not? Or do you not know?
I am not sure. I've spent 5 months in the SITF, so I really don't recall that. But I assume that is the case.
So the SITF ran a different document registration system to the SPO.
No, they did not.
So I'll ask again, does the presence of the letters SITF indicate that the SITF applied that stamp electronically or not, or do you not know?
Actually, thinking about it, yes, it does. It does indicate that it has been stamped electronically.
Can we look, please, at SPOE 0022 0920?
For the purposes of the record, that is P106 MFI, Your Honours, and the earlier document was marked as P86 MFI.
Thank you, Mr. Court
Thank you.
Officer. Can you fit height to page? Thank you. This is a page that you say comes from batch 3. Yes?
Yes?
At the bottom of the page, we see a reference number, SPOE 00220920. That document Was that document submitted electronically then for process by the CEMU?
This document was stamped electronically. And there are two options: that it was submitted in hard copy and CEMU scanned it on a DVD and electronically stamped it. I believe, to recall, this is how this was done here.
So some hard copy documents are not stamped manually. Some are scanned and then an electronic stamp applied to it.
That is correct.
When that happens, what happens to the hard copy document that was scanned before the electronic stamp was applied to the scanned document? Or do you not know?
It is placed into the evidence room.
What if it is not evidence?
My understanding is that everything which we actually, I would refer you to the CMU.
Right. That's candid. If you can't answer, please let us know that rather than perhaps try to guess. Please, if I ask a question and you don't know the answer, just say that, okay? Thank you. And can we have a look, please, at 08344-01-TR-80 revised 1?
Your Honours, we're having some difficulties locating this document in the presentation queue.
It is... can you access the prosecution's presentation queue? We have tried to include even duplicates in our presentation queue of documents submitted in the prosecution's presentation queue, but you understand that sometimes question and answer will lead to reference back to the prosecution's queue.
I don't know how complicated that is.
Could Specialist Counsel please repeat the ERN number?
081344 01 TR AT revised 1.
And for the purpose of the record, that's P1, Your Honors.
This is a document that we don't need to see the full page on, because I'm concentrating on the header, the stamp. This is a document where we have a more conventional ERN number, so not an SPOE number or an SITF number, but it is not manually imposed on the document. It has been typed onto the document. So is it the case that not all electronic documents have a manual ERN number stamped on them? Sorry, that's my fault. I'll rephrase it. Is it the case that not all electronic documents have an SPOE number attached to them?
This specific ERN refers to videos. Videos
It
are
does.
stamped like that.
How is the video stamped?
Like how, the technicality of it, I don't know.
So the video must be allocated a number. Can't be stamped, can it?
What I have seen is that the videos, they receive a surrogate sheet, and on that surrogate sheet there is this number which accounts for the video which is uploaded in the database.
Yeah. So a surrogate sheet is used. The exhibit itself has no ERN stamp in those circumstances.
I would refer you to Simo.
Can we revert then, please, to the declaration beginning 084015?
And that is P86 MFI, Your Honors, for the record.
Thank you. At paragraph 5, you explained that you conducted the review of documents you have labelled as batch 1. Those documents, you assert, were seized by the SPO at the KLA War Veteran Association on the 8th of September 2020. And in direct examination, you referred to the delivery document, which has the stamp 080449. Can we put that on the screen, please? Thank you. You did not attend the KLA-WVA yourself on the 8th of September, is that right?
That is correct.
This delivery document has the date 8th of September 2020 written in hand on it, yes?
Correct?
There is an ERN number stamped at the top. That ERN number would have been added at some point after the attendance at the KLA War Veterans Association on that day. Do you agree?
It was added when it was submitted in Xylab, obviously after.
Do we have a date for that?
We do, but I cannot recall.
So what we do have in court is this document, which did not have an ERN number on it at the time of the visit to the KLA-WVA, yes? Yes?
Yes, yeah, sorry.
And the other information we have, what is the item described as under across in the row marked ref?
Shall I read it out?
Please.
It states documents delivered to KLA-WVA.
And the full extent of the description of the content as of this note?
One stack of documents printed.
And no further information. Do you agree?
I agree.
We don't know how many pages from that document.
No, we don't.
We don't know how big the stack was.
No, we don't.
We don't know what the documents contained at all.
No, we don't.
And do we see any reference to, for example, an evidence bag number on that delivery document?
No, we don't.
So if they were put into a bag, this on the 8th of September at the KLA-WVA, the delivery document that we have doesn't help us with what bag that was.
That is correct.
Of the documents that you reviewed, and we can revert, please, to the declaration, Mr. Court Officer. Thank you. Of the documents that you reviewed and labelled Batch 1 then, when did you conduct your review of those documents?
I have conducted this review sometime after the search at the War Veteran Association.
Well, I'm grateful for that, but can you be more specific? When did you conduct your review of the documents you have labelled Batch 1?
I cannot recall the exact date, but it was very close. I started the review very closely after the search at the War Veteran Association.
When you say the search, you are referring to the search that you conducted on the 25th of September?
That is correct.
So it was at some point after the 25th of September, yes?
That is correct.
Can you give an indication in terms of days or weeks or months? How long after the 25th of September?
It was not months.
Did you record the date of your review on your contemporaneous notes?
Can you repeat, please?
Did you record the date that you conducted your review of the documents you've labelled batch 1 in your contemporaneous notes?
I think for clarification, this review was work in progress. So I reviewed in more detail as I drafted the declarations, and in anticipation of the testimony today, I also went back to my prep work in order to better familiarize myself or to recall the methodology, how I came to these findings.
So your review commenced at some date, you think soon, after the 25th of September, but continued right up until 2 weeks before you started giving evidence?
On and off.
Can you tell us the days on which you were engaged in your review of the documents you label batch 1?
No, I cannot.
Would your contemporaneous notes have assisted with recording those dates?
Maybe time stamps.
So the answer is yes.
Yes.
Had you seen any of the documents contained in what you label as batch 1 before you commenced your review shortly after the 25th of September?
No, I have not.
Not a single document?
I don't think so.
In paragraph 6 of the declaration, you described batch 1 as counting 891 pages, with documents in English, Serbian, and German. You speak very good English. I assume you speak German. Do you speak Serbian? Or did you have assistance with translation of Serbian?
Both.
When you sought the assistance of translation, was any record kept of the translation?
Yes, there was.
And where is that?
It's in the database.
Any particular database? Scilab, DT, CaseMap?
It is in the internal database. You would find it with DT, not in Xylab.
So, a document not submitted for evidential purposes?
That is correct.
No stamp on it, therefore,
That is correct.
but nevertheless retained within the SPO's record-keeping system, yes?
That is correct.
You, in paragraph 7, assert that batch 1 includes confidential requests for assistance, yes?
Correct.
Did you mean to assert that those requests for assistance were confidential?
Yes, they were confidential requests.
If that is what you meant, let me ask you to assist us with your understanding of what confidentiality involves. did you consider, when making that assertion, that the requests were confidential, the extent to which it was necessary for those requests to be classified as confidential or not?
There is an objection, Your Honor. It's the same line of questioning that the Council posed yesterday that was already overruled.
You wish to respond?
I did lay the groundwork. I did ask her if she meant to assert that the requests were confidential. She has maintained that that is her assertion. In assessing that, we need to understand from her what factors she took into account or did not take into account when reaching that conclusion.
But are you suggesting that she is responsible for deciding what is and is not confidential? Because if she isn't, that's an improper question.
I do not assert that she is responsible for deciding what is confidential and what isn't. That can only be the trial panel's prerogative.
You might want to ask her if it is within her scope of authority to make a decision on what is or is not confidential, because that's what you're asking her. You're asking her to decide, to tell us, to describe to us the necessary elements to make something confidential, and I don't know that she has that ability.
No, and I with respect, adopt the concise formulation that Your Honour has suggested to me, and I will put that to the witness.
All right.
But
Go ahead. I'll overrule your objection at this time. He can ask that question. I don't know how much farther it can go, though. Depends on her.
Well, I would like to return to that, if I may, and perhaps I can ask the question and then return to it, or we can return to it at a different time. But of course, Your Honour will understand that we are in an unusual environment where the prosecution are relying upon the analysis, as she has described it, of documents that you will not see and we have not seen, and the identification by her of the relevant features of it. So I will, let me ask the question.
Yeah, I think I fully understand your position on that, but I have a problem with what you're going to ask her and how far it goes.
Microphone, please.
Judge Mitro has a question for you.
Thank you, Judge Smith. It's more a suggestion and not a question, and it's of course one you are free to take or not to take, but why not ask her what factors she took into account to determine that something was confidential? Was it markings? Was it the content? I think it would go much faster if she lays the ground for what factors she took into account for the purpose of determining whether something was or wasn't confidential, rather than asking her whether something is relevant in the abstract or in theory. She did not make that determination. She took into account, as we understand, factors, and you can ask her what those factors are.
I'm grateful. First question, do you regard yourself as having the authority to classify documents as confidential or not?
I do not.
The second question then is, what factors did you take into account when you conducted your review, when you were looking for features that pointed towards confidentiality and pointed away from confidentiality?
I make reference to my declaration, 9th May 2021, the annex to the column indicia suggesting confidentiality. I have made this assessment based on what I have written in this column.
And we will look at those charts. I'm conscious that you haven't been asked to yet by the Specialist Prosecutor. But before we do so, keeping it general, can you assist us now with what features you took into account which you thought pointed towards confidentiality, and what features you considered might point away from confidentiality?
I have reviewed document by document, and I have listed for each document features which I believed indicated confidentiality, such as that it is specifically stated on the document that it is confidential, that the document, for instance, had a case number, was issued by the war crimes prosecutor of Serbia, the police of Serbia, or by the SITF, that the document contained information about crimes, that the document contained details of individuals, witnesses or potential witnesses, personal details, that the document contained narratives or information about crimes.
So you did not consider whether, for example, any claim for confidentiality was with authority?
Would you please rephrase that?
So you did not consider where, for example, you saw the word confidential attached to a document, whether there was proper authority to classify the document as confidential?
No, I did not.
Or whether that the process of classification was lawful?
No, I did not.
Or whether classification of confidentiality was necessary?
No, I did not.
Or whether it was being used to conceal abuse of authority, for example?
Objection, Your Honor. The witness already stated the factors that she took into consideration. This is a suggestive line of questioning that the witness, yeah.
Microphone for Your Honor, please.
Sustaining the objection, the question's already been asked and answered. You're trying to add addition to her testimony that she is not willing to make.
Well, can I make it clear, Ms. Pumper, that, of course, I can only ask the questions. Your testimony comes from your answers, and you answer how you see fit, okay?
Okay.
You talked in paragraph 7 of your declaration about competent Serbian authorities. Which were the competent Serbian authorities you refer to?
What I referred here is the Serbian War Crimes Prosecution Office.
And what was competent about that office?
I think what I try to say in this, using this word, it was our counterpart, our appropriate counterpart to address these requests.
What was appropriate about that counterpart?
Maybe I don't engage in a conversation about using the proper word. What I said, what I wanted to say with this sentence is that the SITF addressed the Serbian War Crimes Prosecution Office as our counterpart, who we were supposed to address these to.
Paragraph 7 refers to authorities, Serbian authorities, not just the Serbian War Crimes Office. Which other Serbian authorities were you referring to?
The Serbian authorities, I refer to the Serbian War Crimes Prosecution Office as well as the Serbian police.
Do you use the Serbian police as a broad term to cover other agencies, or is that a specific term? Which agencies of Serbia are you referring to?
The Serbian police.
And what was competent about the Serbian police?
I prefer not to engage in further conversations about the word competent.
Well, it's your word. It's from your declaration. This is the evidence that the SPO apply to adduce in written form, and that's the word you've used. So what is competent, please, about the Serbian police force?
There is an objection. The witness already answered this question. She explained what she meant by the word competent as the authorities that were addressed.
She did. The question's been asked and answered. Maybe you're not satisfied with the answer, but it is her answer.
I do, of course, understand Your Honour's position there, but part of cross-examination is an exercise in testing the evidence, and just so I understand the ground rules, I do not take it that the trial panel expect counsel not to be able to probe an answer.
You can certainly probe an answer, but hers was quite definite.
Your Honour. And you talked about Serbian authorities designating documents as confidential, yes? You said that earlier to me.
Mm-hmm. Correct.
And who were the persons designating documents in Serbia as confidential?
I do not know who the persons were. I reviewed the documents which had these designations, and they were offered what appeared by Serbian institutions.
Did you check the authority of such persons to designate documents in Serbia as confidential?
No, I have not.
You check whether, for example, appropriate delegations had been made in Serbia for documents, Serbian documents, to be classified as confidential?
No, I have not.
You refer to the presence of SITF logos.
Correct.
There is nothing confidential about the SITF logo. It's a public logo. Do you agree?
It is also a public logo, yes.
When you began your review, you were aware, were you not, that the origin, authenticity of these documents were very much an issue?
No, I was not.
Can you, Mr. Court Officer, please pull up 08135 8 01 TR ET revised, which should be in the defence presentation kit. And go please to page 4, line 21. This is a transcript of an interview on the 8th of September. So, 8th of September 2020, so shortly after the first disclosure, if I can use that phrase. Obviously, you were aware that there was significant press interest into the events on the 7th of September. Do you accept that? There was significant press interest.
Do you mean at the time?
At the time, yes.
I did not pay much attention to this at the time because I was involved in other line of work.
Right. So you didn't become aware of newspaper reports or TV programs covering the events of the 7th of September until much later. Is that, are you saying that?
Yeah, that is. I mean, I did not pay attention to them. I obviously heard about it, but I did not research it.
So can we leave the document on the screen there, please? So we can see there, the newscaster who was interviewing Mr. Gucati, he asks, and we've got the video of this, are there any signatures? Are there any official stamps? Are they originals? Mr. Gucati says no, they're copies. The newscaster asks, are they fake? Mr. Gucati goes on to say everything is possible. They could be fake, they could be. And if you go on, please, to page 6, line 2, at the top of the page, again, Mr. Gucati says, we haven't verified them. Officially, we cannot say whether they are fake or genuine. And if we go on now, please, to page 7, line 24. We haven't looked, Mr. Gucati says, and checked the whole documents which are shown on the screen. There were a lot, over 4,000. We only looked into some documents and checked them, and at a certain point, lists, different ones, appeared that there were within the bundles. Normally, the Kosovo Prosecutor's Office should do the verification and determine if they're fake or genuine. So, are you saying that you weren't aware when you were undertaking your review that whether the documents were fake or genuine was an issue?
I don't recall knowing that that was an issue.
And can we look, please, at item ERN 082106. Dash 01 dash TR dash ET.
Interpreter's note. Interpreter's note. We kindly ask the speaker to read slowly when quoting. Thank you.
Therese.
Thank you. Can we go to page 10, please, line 26? Mr. Gucati, so we've heard him raise the origin, authenticity of the documents on the 8th of September, now the end of the period in September that we're concerned with. He's interviewed again, and he says, as we have said, we've invited the Kosovo Prosecutor's Office and Kosovo's investigators, but also the foreigners, the court, and such bodies who leaked these files. Was it the Serbs? Or were they brought from somebody from the prosecution? Or whoever? Or are they fake? Or what? It would be helpful if they're investigating this case and bring it to a conclusion. So back to the declaration, please. Again, you weren't aware when you were undertaking your review that the authenticity of the documents was an issue?
I don't remember whether I was aware when I wrote this specific, the 29 October declaration. I don't remember. That is my answer.
When you were... Well, how did it come about that you commenced your review? Were you asked to do it, or did you do it through your own initiative?
I was tasked to do it.
Were you tasked by document or by conversation with a colleague?
I don't think I received the document. It was a verbal conversation.
Was that verbal conversation subsequently minuted?
Not to my knowledge.
Did you send an email back to the person confirming informally what you had been asked to do?
Not that I recall.
Is that usual operating procedure for the SPO?
Yes, it is.
So the normal operating procedure within the SPO is that you would be tasked to undertake actions verbally without any record being kept of what you're asked to do.
That is correct, yes.
And the SPO has been operating since 2015?
16 June, I believe.
2016. It's not exactly an organisation that could still claim to be going through teething problems.
Objection, Your Honor. It's a comment from the Council, not a question.
Sustained.
Who verbally tasked you to undertake this review?
Miss Bellici.
What did she ask you to do?
I don't recall the details.
That is why written action would be a useful document to have, would it not?
It's another comment, Your Honor. There is another objection.
Sustained. Just ask questions.
When did Miss Bellici verbally ask you to undertake the review?
I don't recall the date.
And that's not recorded anywhere either.
I can't confirm in the positive, neither in the negative.
Did she explain to you what she envisaged the purpose to be?
Yes, she did.
What did she say?
I don't recall the details.
Right. Okay. Let's do it as general as you can to begin with. Did she say why you had to undertake the review?
I don't remember.
Oh. How many times have you spoken to Ms. Bellici about your review that continued from sometime, we don't know when, after the 25th of September, up until about 2 weeks ago? Again, we don't know exactly when.
There were numerous conversations in due course of these reviews.
How many?
I don't remember.
When you spoke to Ms. Bellici about your ongoing review, after the first unrecorded conversation which you were tasked to begin it, did you make a record of subsequent conversations with her?
I did not make a record of verbal conversation, but there is some record of emails going back and forward.
How many?
I don't remember.
Have you reviewed them recently?
No, I have not.
During your subsequent conversations with Ms. Bellici about your review, when did she raise that the authenticity and origin of these documents were an issue in the case?
I don't recall.
Did she ever raise with you that the authenticity and origin of these documents were an issue in the case?
I don't remember that, but I remember that I did check authenticity.
In your declaration, though, none of the declarations do you, I think, address authenticity. Is that right?
That is correct, yes.
Right. So you're saying that you did consider authenticity, but you didn't record your findings or consideration and what you did to consider authenticity anywhere in a formal declaration?
The authenticity review started later, to my recollection, and as I went and did the review for the purpose of writing this declaration, authenticity question was answered as I went ahead.
Where do we find that in one of your declarations that have been served, setting out the scope of your evidence?
I have not completed the review of authenticity to this date.
It's ongoing.
I have not completed it. Meaning I have not checked every single document whether it is authentic.
Meaning your review of authenticity is ongoing. Do you agree with that?
Meaning that I have not continued my review of authenticity, and I'm not tasked to continue.
Have you been asked to stop it?
I have not been specifically asked to stop it, but I stopped it when I stopped reviewing the material.
Can you clarify this? Because, I'll rephrase. Can you clarify this? Were you ever specifically tasked to review authenticity then?
I believe I was at a later stage.
When?
I don't remember.
In writing?
No.
By who?
I believe, to recall, it was a conversation with Miss Bellici.
Can you tell us roughly how long ago that was?
I cannot be certain.
as part of your review of these documents, did you carry out yourself or ask anyone else to carry out any forensic science examination? So, for example, any fingerprint analysis?
I have not done it myself, and I have not asked anyone to do it.
Are you aware if anyone else within the SPO has been asked to conduct or to put in place a forensic science examination of the documents, such as fingerprint analysis?
I have no information about that.
The documents you saw and you have labelled as batch 1, they were original documents or they were copies? Or could you not say?
They were copies.
So, for example, you never saw any wet signature on any of the documents contained within batch 1?
I did not.
Can I ask about the process for classification of confidentiality within the SPO? Are there designated persons with the authority to make such classification?
I don't know that.
You do not know?
No.
Is there, and again, tell me if you do not know, but if you do know, can you help? Is there a process for the consideration of confidentiality?
If there is, I'm not involved in this process.
So you cannot help us with whether there is a process by which an evaluation of the necessity of
Objection, Your Honor.
takes place? You're not aware of whether there is a specific process through which an evaluation of necessity takes place before confidentiality is designated?
Objection. The question has already been answered by the witness. She said she's unaware.
I'll allow that one more question about it. You may answer that.
I'm not involved in this process, and I'm not aware of it.
Can I ask one further question? It's about her direct knowledge.
She already
And
told you yes.
I've got no doubt Your Honour will stop me, or at least stop the witness from answering if I ask it, and Your Honour
Go
thinks
ahead.
it's going too far. But have you ever seen a document within the SPO recording the reasons for designation of another document as classified?
I don't recall.
Does that mean that you have or may have but don't remember? Or does it mean you have never seen such a document?
Your Honor, she said that, objection, that she does not recall.
Yeah, and you said one more question, and you asked it
That's too
in,
high.
and you got the same answer, and you're going to get another one just like it, so.
We're simply seeking to clarify whether she meant she didn't recall whether she's seen such a document or she did not recall such a document.
Madam, answer the question.
I don't recall having seen any documents. I don't know whether such a document exists.
Okay.
I'm grateful. Thank you. That is clear. Thank you. Slightly early, but that is a convenient moment in terms of topics to break for the break.
Oh, all right. Okay, Ms. Pumper, you will be escorted from the room.
Thank you.
And please be back, Ms. Pumper, at 11:30.
Thank you.
And do not speak about your testimony with anyone else.
Yes, I won't.
And Mr. Cadman, just as soon as she's gone and the door is shut, we will recognize you.
Your Honour, nothing related to this witness. Just to respond, the SBO have quite properly pointed out this morning that in relation to our expert witness, witness 17, the instructions have not been provided. They will be provided, filed today. It was clearly an oversight that it wasn't, because it was in the order, and of course those instructions will be provided. The second point is just for a point of clarification. We intend to call a second expert witness that has largely come from necessity from this witness's testimony the last couple of days. It was really to provide guidance on whether I will be required to make an application to add an additional witness, or whether your honours want to give a direction as to the timeline in serving a further expert report.
Just go through the regular procedure.
Certainly.
All right? We are adjourned. We'll be back here at 11:30.
All rise. All rise.
Please be seated. Please bring in the witness. Be seated.
Thank you.
Mr. Rees, you have the floor.
Thank you, Your Honour. Ms. Pumper, paragraph 7 of your declaration beginning in 084015 summarises the documents you label batch 1 as including requests for assistance dating between 2013 and 2015. As part of your review, did you ever consider the term or duration of any classification of confidentiality?
No, I did not.
Or did you consider whether steps have been taken to declassify or reclassify?
No, I did not.
And you told us that all the signatures you saw were copies. They were never a wet original signature. And that you were not aware of any forensic science examination of the documents, such as the examination for fingerprints. Is the answer the same in relation to, for example, any forensic inquiry into the authenticity of signatures represented in the documents?
I am not privy to any inquiry other than the one which I have done.
We may come back to that. Paragraph 7 continues, referring to the SITF logo. You refer to the SITF address. An address of the SITF, that wasn't confidential?
Is that a question?
That is a question. Nothing confidential in the address?
I have stated what I considered could indicate confidentiality when I listed the indicia.
But the address of the SITF, where it was based, that was publicly known knowledge?
It was also public knowledge.
Thank you. And the contact email address for the SITF, again, publicly available knowledge?
I believe so, yes.
And the website address of the SITF, publicly available
I believe so, yes.
knowledge? Paragraph 8, you assert that most of the requests included in the documents you label batch 1 were composed of a cover letter and annexes. Now, just pause in there. Clearly, you are dealing with the general position in this first declaration, yes?
Yes.
And in general, it's right, isn't it, that the cover letters that you refer to, those letters themselves were not marked as confidential.
I would refer to the annex which I created. There it's explicitly written whether the cover letter is marked confidential.
Well, as I say, we will reach those charts in due course. But in fact, the charts do not explicitly mark whether or not the letter was confidential. So I'm asking you, because you've seen the documents, you say, to confirm that in general, the cover letters are not claimed to be confidential.
Your Honor, I would like to ask the counsel to specify to which assertion of the witness he is referring, and also she already answered this question.
Please try to comply with the short inquiry from the prosecution. It could elucidate your question a bit.
Okay. Your answer to my previous question, Ms. Pumper, was that you would refer to the chart which set out whether the cover letter was expressly marked as confidential or not. And I explained that we would reach your charts in due course. When we do, we will see that they do not set out, in fact, whether the cover letter is marked as confidential or not. So I will ask you again, in general terms, as you have approached paragraph 8 of this declaration, the cover letters, in general, do not mark themselves as confidential, do they?
If I can state, I have
If
said...
I may object, sorry. I'm not sure what the counsel is referring to when he says that the witness says that the cover letters in general are not marked as confidential.
I understand the question. Your objection's overruled. Answer the question as directly as you can.
I have written that it included such documents. That batch 1 most requests included in batch 1 are composed of cover letter and annexes.
That's not the question.
Can you repeat the question, please?
The cover letters themselves are not marked as confidential, are they?
The majority not, I believe. Yes.
Thank you. There are markings you have recorded in your charts and referred to at paragraph 8, where the cover letter refers to an annex as being confidential. Yes?
That is correct.
The cover letter, again, we're dealing in general terms, may or may not be signed, yes?
The cover letter is signed.
But the annexes are not.
That is correct.
And what you describe in paragraph 8 is the SITF revealing the names of witnesses or potential witnesses to Serbian authorities. Yes?
That is correct.
So even on the face of your review of these documents, we have the SITF sharing the names and personal details of witnesses or potential witnesses to a third party outside, external to the SITF.
That is correct.
What do you mean, just so we understand your evidence, when you refer to a witness?
When I spoke about a witness is a person the SPO expects to, a potential witness the SPO expects to receive information from, and a witness is someone who has been met or who has given an interview to the SITF, SPO, or another organization. More or less, that's it.
The SITF may expect to receive information from anybody that it speaks to. Yes?
Evidence, yes.
Right. So we are not dealing with information, actually. We have clarified it so that when you refer to a witness, you refer to somebody who the SITF expects to obtain evidence from. Yes?
Sorry, I would like to correct. What I mean is that when I speak about witness, potential witnesses, it is that the SITF is expecting to obtain information which is relevant to the mandate. We also meet people who are not providing information which is relevant to our mandate, to the investigation.
We'll explore that a bit further in a moment, but if that's right, what is the distinction you draw between a witness or a potential witness?
A witness, for this purpose of this review, I consider a witness whom the SITF has met or has obtained an interview or has obtained interviews from other organizations, registered in the global witness list with a witness code.
But the SITF must have met hundreds of people that it would not regard as witnesses. Do you accept that?
I don't know that.
So, is your approach then to simply list the name of any person the SITF has ever had contact with as a witness or a potential witness?
In what context? I don't understand now.
Well, your answer a moment ago was a witness for the purpose of this review. I consider a witness who the SITF has met or has obtained an interview or has obtained interviews from other organizations registered in the global witness list with a witness code. So I understand the later parts of that sentence, but are you asserting there that you consider a witness to be somebody who the SITF has met?
Someone that I consider a witness or a potential witness, someone who the SITF has met. Both.
Any person?
I said someone who the SITF has met and whom we sought to obtain information from, which is related to our mandate, to the investigation.
Right, so we can exclude persons that a staff member of the SITF has met for purely social reasons. I understand that. So are you saying that you then listed as a witness or potential witness any person whom an officer of the SITF has met in the course of his duties?
From whom he sought to obtain information which is relevant to our mandate. Yes, that is what I say.
And what is the distinction between a witness or a potential witness then, for the purposes of your review?
When you look at the SITF requests, anyone listed there by name, the SITF sought to obtain different materials, either to obtain previous statements or to have an interview. So someone who has never met would be a potential witness. Someone whom we ask them to identify, does this person exist, is a potential witness. People whom we had contact, I would understand, or whom we want to contact for interview is a potential witness. Someone we have met, from whom we have obtained information in a meeting, or someone whom we have formally interviewed, I would consider witnesses for the purpose of this review.
Does that include where the information received from the person is negative, in the sense that the person says, I have nothing to say, I know nothing, or I'm not going to speak to you?
At a certain point of the review, I have excluded individuals when I did the checks who have died, who have refused to cooperate with us.
When did you do that?
I did this, to my recollection, after I have written this declaration, certainly before I have produced the annex of Declaration 9 of May.
Where do we find in your declaration then that produced that annex the details of your review to exclude persons who are dead or provided negative information?
As you can see in the annex to the declaration, there is a column which refers to witnesses yes, no. And I think I have mentioned yesterday or the day before that I went through the documents and I identified in each document at least one individual whom we have met or interviewed and who I dare exclude was not cooperative or had died.
One.
Yes, one, at least one. That was what was done.
So I'll repeat the question I asked. Where do we find in any of your declarations the details of your review to exclude persons who are dead or provided negative information?
I have not reported on this in the declarations.
What about names of persons that were never located?
They would not be included as a yes in the column.
And why is that?
Because they were never located.
The requests appear on your analysis to precede the SITF speaking to a witness or potential witness?
Can you please repeat or rephrase?
The requests on your analysis would appear to precede, go before the SITF actually speaking to the witness or potential witness.
I cannot be certain because potentially the SITF has met with someone and then had a follow-up request. I cannot exclude that possibility.
And on the face of your review, it would appear that there are also communications following up on earlier requests. Is that the general picture?
No, what I need to clarify that I looked at each request as an individual paper and I did the research. So I did not investigate this specific request, what happened before, what happened after.
And I'm sorry to repeat the question because I don't think, I will do because I don't think you've answered it. What is the distinction you draw between a witness or a potential witness?
Question has been answered. There is an objection to that.
Sorry, I had my mic off. Overruled. You may answer the question.
So we have, I spoke about in the declarations about potential witnesses and witnesses. Potential witnesses are individuals whom we sought information from. Witnesses are individuals whom we have met and obtained information from, or witnesses who have been interviewed, and witnesses who have provided interviews to other entities.
So, in the column names of potential, that's in brackets, names of, brackets, potential, close brackets, witnesses, yes, no, where we see yes, that might only designate that somebody has given an account, given information within the scope of the mandate of the SITF, even if that information was given to a completely different organisation.
I would like to look at it in connection with the fact that someone has given information to a third organization that is for me a potential witness because we are interested in locating the person.
So, for example, if the SITF saw the name of a person who had given an account to a newspaper that the SITF thought was of interest, you would identify that name as a witness or potential witness in the yes-no column on your chart.
I didn't have this case, and I believe I would have consulted with the prosecutor on that question.
Are there many rows within your charts where you have consulted with the prosecutor about the row?
No, they are not.
How many are there?
There are only 2 rows in which I consulted the prosecutor with.
Dealing with the chart for batch 1, which 2 rows?
It is the row description and the row page number, I believe.
So is it, do you mean column of the
I
chart?
apologize, column,
I see.
yes.
So you consulted with the prosecutor, the columns, description of document and page number. So we'll leave aside the page number for now at least. Are you saying that you consulted with the prosecutor as to the contents of the column description of document for each row?
No, I did not.
Tell us about the consultation you had with the prosecutor about the description of document column.
After the pre-trial judge ordered that I make this spreadsheet, I started doing it, and then I realized that defense would most likely struggle to better understand these documents if the column description is missing and the page number to understand how big the document is. So I went to the prosecutor and I said I would propose to add those two columns so that the defense can better understand what this document is about. That was the only conversation I had.
And when did you have that conversation with the prosecutor?
It was very much at the beginning of my research when I drafted the annex, because I noticed it when I looked at it after a few documents.
You mentioned earlier about the provision of information to other organizations. That would include, I take it, the provision of information to Serbian authorities.
I apologize, I don't know in what context. I don't understand your question.
When we were discussing your definition of a witness or potential witness for the purposes of preparation of your chart, you said that you would include a person who had given information to other organizations as a witness or potential witness. Would those other organizations include Serbian authorities?
Yes.
Which Serbian authorities?
What I have seen is statements given to the police, to the Serbian police.
Any other Serbian agencies or just the police?
I recall only the police. But in any case, it would have been specified in the annex.
What other third-party organizations, then, other than the Serbian police, were you referring to?
For the purpose of this review of batch 1, to my recollection, there were only information given to the Serbian institutions, but that is specified in the annex.
Again, dealing with the general proposition as you've spelt out at the end of paragraph 8 of this declaration, the last sentence of paragraph 8, you say that there were requests contained in the document you label batch 1 that included correspondence concerning logistical arrangements to carry out interviews and expressly refer to the confidentiality of the SITF investigations. It is right, isn't it, that those letters do not claim themselves that the logistical arrangements to carry out interviews were confidential.
These are letters which exactly say what I wrote here. They expressly refer to confidentiality of SITF investigations. I think I have provided a sample in the second annex of Declaration 9 May, which actually contains the exact sentence.
And we will look at the sample in due course, but there are, on your account at least, many, many hundreds of pages that we have not been provided with, and the trial panel will not be provided with. You say that you have seen them, so I'm asking you about the general picture. It is right, isn't it, that those requests, even if they expressly refer to the confidentiality of the SITF investigations, do not claim that the logistical arrangements to carry out interviews set out were confidential?
I would have to look at this document, but I wouldn't agree with you. I think they expressly refer to the confidentiality of the SITF investigations, and the letters are written in order for the War Crimes Prosecution Office to make arrangements for the SITF to conduct interviews at the premises.
Well, we are going to look at a tiny, tiny number of samples. But I'm asking you about the other several hundreds of pages you claim you have seen. Are you saying that you would need to look at those documents again to examine the question that I've asked? Do the requests, whether they refer to the confidentiality of the SITF investigations or not, do they, any of them, not claim that the logistical arrangements to carry out interviews themselves were confidential? Would you need to look at the documents?
I can confirm that there are only a handful of these kind of documents in the batch. My answer is that they expressly refer to the confidentiality of the SITF investigations, not the confidentiality of them getting into the building or something. But I'm happy to go to the document and confirm. But this is what my statement is.
Shall we go to the documents?
We don't need to if you don't want to.
Well, we produce the full documents and we will go to them. Every one of them.
Your Honor, is not a question for the witness.
Sustained.
Well, I'm glad that you're happy to go to the documents, Ms. Pumper, but we cannot. So I will move on. At paragraph 9 of the declaration, in the last sentence, you assert that the annexes to requests name witnesses and potential witnesses who have never been publicly identified by the SITF or the SPO. How do you know they've never been publicly named by the STF and the SPO?
To my knowledge, they have not.
And your knowledge is based on what?
I asked the prosecutor specifically whether she's aware of any of those being publicly identified, and she said no. And from our procedure, we don't tend to identify evidence to the outside world.
So it's Ms. Bellici's word we take for that assertion then?
I think what I'm trying to say, that working in this office for a few years, I have not seen that we have publicly disclosed any evidence. We conduct...
you don't tend to publicly disclose the names of persons who face an unconfirmed indictment, but you do, don't you?
Pardon, say again.
I'll ask the question again.
Objection to this, it's argumentative.
Ask a straightforward question. I'll repeat that. Ask a straightforward question. My mic was off.
I will do my best. You have rules in place that require the names of persons on unconfirmed indictments to be undisclosed. Do you agree? You have rules in place not to disclose the names of suspects on unconfirmed indictments. Do you agree?
I have not studied the rules.
Right. Well, that's very candid as well, so thank you for that. Right. So, moving away from what Ms. Bellici has told you, what about whether witnesses and potential witnesses have been publicly identified by Serbia?
Are you asking me whether I'm aware of any?
Yes.
I don't know.
Thank you. Or made public by the witness themselves?
I don't know.
Thank you. Do the names that you refer to include the name Vladimir Vukcevic?
I have not stated that in the specific declaration, but I can confirm I have reviewed that.
You have included that name?
I have checked that name, yes.
Yes. And you included him of you as a potential witness or witness?
He was not part of the review when I wrote this declaration. So he's not in the spreadsheet. He's not considered in the spreadsheet.
I see. So he is not a name that your review regards as a confidential name?
No.
And of course, it is public knowledge, isn't it, that the SITF, at least, has collaborated with Vladimir Vukcevic because the statement of the Chief Prosecutor of the Special Investigative Task Force has praised him for his assistance.
Objection, Your Honor, is not a question for a witness, it's a statement from the counsel.
I'm asking her to confirm that.
Microphone, please.
Thank you, Your Honor. Apologies for acting too prematurely. You can confirm, can't you, that the Chief Prosecutor of the SITF has publicly praised Vladimir Vukcevic for the assistance that he has given to the SITF?
I was unaware of that.
You were not aware of the statement from the Chief Prosecutor dated the 29th of July 2014?
She's already answered that, Counselor.
At this point, can I ask for the assistance of the trial panel? You will see, Your Honours, that at paragraph 10, there are 4 names that are referred to. Our position is that they are publicly available names and they are referred to in publicly available documents. Our position is that these matters should be heard in public. I wish to ask about those names. So I do not invite the court to go into private session. But I am aware, of course, that it is a matter for the trial panel.
Your Honor, and the prosecution position is that this line of questioning should be in private session. Yeah. Also, if I may, Your Honor, just that. Yeah. just to add that the panel has authorized redactions on this part for the public available document.
Yes, I understand your point, Ms. Prosecutor, but we do have to get on with the questioning. We don't want those names mentioned aloud. You can certainly show her those names and ask her whatever questions you have about them, but we are not going to repeat the names or any personal detail. Understood? If you want to repeat the names, then we will go into private session.
So it's not, I understand that Your Honour's helpful indication about the names, but I do want to ask some questions about it, whether that is information that is personal detail or not. I'm in the trial panel's
It's
hands.
very difficult to know where you're going with that by the statements you made, but we are not going to, in no way, no identifying information should be revealed.
Well,
That would include their occupation, a
well,
variety.
then we will have to, I'm afraid, if that is the trial panel's position on it, then we will have to go into private session.
We will go into private session because of the... Mr. Haradinaj, please remain quiet, Mr. Haradinaj, and do not interrupt
You're in public session, Your Honours.
All right, now we're back in public session, and you may continue your cross-examination.
Thank you. Can we move on to paragraph 13 of this declaration? The declaration beginning 084015. Pause there. As part of your review, you examined public source, publicly available web pages, is that right?
Articles.
Sorry?
Articles.
Articles. And they were identified by other members of the SPO in the first instance?
That is correct.
And then brought to your attention for your review, and the purpose of it was to look in particular at both images of documents published by those news agencies, yes?
That is correct.
And also the content of the articles published by those news agencies, yes?
Please, if you bear with me a moment, because I've reviewed many. I reviewed the article for the purpose, for the photographs, not necessarily the content in the context of the case.
But during the course of your review, you saw the content of the articles?
Yes,
Yes. Have a look at paragraph 16, for example, where you specifically refer to some of the content. Yes?
I state the title of the content.
Yeah, you
Of the
also
article.
talk about what the article mentions there in paragraph 16.
The names, yes. I
you.
apologize, yes.
So, go back, please, to paragraph 13. When did you review the article referred to there?
I reviewed this article for the purpose of writing this declaration.
And when did you review that article?
I don't remember the specific date.
The article is at ERN 081364 -081368. I hope. So that's the English translation. Can we have a look just briefly, perhaps keep them both, keep the English translation up, please, Mr. Court Officer, and if we can produce the original printout, as it were, ERN 081364 -081368.
purpose of the record, Your Honours, Specialist Counsel, we only see the English version.
Can you look at the prosecutor's presentation cue?
Under this ERN range, we only have the English.
Well, we will seek to remedy that and, if necessary, revert back to it. But that, and tell me if you think you can only answer if you see the document. But we can take that down for the moment, please, Mr. Court Officer, in the circumstances. The article that you refer to in paragraph 13 is published by gazettainfocus.com. Yes?
Yes.
I would like to ask clarification. Where is the counsel reading from?
There we are. Thank you very much.
Counsel, will you tell us what you're reading from? Counsel, will you tell
Yes.
us what you're reading from?
I was reading from my notes there. Can we, I think, go on to 081364? Now, okay, what we will have to do is we'll have to add this document to the presentation queue.
Perhaps you can do
So
that.
we'll
during-
move on.
You,
In
you
the
can do
break,
that
we'll
during the
sort that
noon
out.
break.
We'll revert back to it. Okay. It's in there.
It's there.
Where? So can we have a look at 081364, please? Right. There we are. Thank you very much. There we are. There's the answer. There's the website. Okay. Now that is still publicly available, is it not, in full? Can you see it at the top of the page?
I don't know whether it's currently still available.
Right. You haven't checked, have you?
No, I have not.
Anyone in the SPO bothered?
Pardon me.
Is anyone in the SPO bothered? Or can you not answer that question?
You mean checked for...
Could you use a different phrase than bothered?
Thank you.
Yes.
You are not aware of anyone in the SPO asking the court for an order, for example, to Gazetta in Focus removing that article from the internet?
I have not.
No, thank you. And it's authored by, was published by Gazetta in Focus, and we can see the author is Halil Barisha. Can you see that underneath the first image?
Yes, I can.
Thank you. Can we look, please, at 081361 to 081363? And here we see we can take down the document to the right of the screen, please, now, Mr. Court Officer. And if we can fit to height, please. Thank you. We can see there, this is an article. Again, gazettainfocus.com. Yes?
That is correct.
Author Halil Berisha.
Yes, that is correct.
And we can see that a website, webpage gazetinfocus.com/EKSK.
Slowly, please.
Thank you. I'll start again.
Is there an ERN for it? So, do you want to, is there some reason you refer to it by this
Yes.
website rather than the ERN number?
Absolutely, because I want to ask the next question, which is, and that web page is still publicly available in full, isn't it?
I don't know.
Can we scroll up slightly? Can we reduce to fit to height, please? Thank you. And your declaration provides, paragraph 15, that you say that document in the middle of the image, imposed in the middle of the image, appears to depict SITF Coordination Request 112. Yes?
Correct.
And you say that you could read that from the article itself.
No, I enlarged it for the purposes of this review.
Okay, so your evidence is that anybody who can enlarge the image, which is quite a straightforward matter for anyone with a computer, could ascertain that that is SITF Coordination Request 112.
My statement is that I could.
Well, it's not. The statement is the picture included in the article appears to depict SITF Coordination Request 112. Dated 11th of June 2015 is how you put it in paragraph 15. Yes?
I would like to be clear. When I write appears is when I look at it like this, I can confirm that when you enlarge it, that you can recognize it's 112.
And anyone could recognize it from that publicly available webpage published by Gazzetta in Focus and authored by Halil Berisha. Yes?
Can you say again, please?
And anybody could recognize it from that publicly available webpage published by Gazzetta in Focus and authored by Halil Berisha. Yes?
Objection.
I can't.
Yeah, objection. The witness can answer about what she can do, not about what everybody else can do.
It's asking for an opinion on her part about this. Obviously, not everybody could. Somebody who is blind could not read it. So it's an improper question.
I appreciate the caveat that Your Honour adds. Obviously, someone who's blind could not. But anyone who's not blind could. Do you agree with that or not?
I don't agree with that, actually.
Thank you. Can we look, please, at 081362? What about that document?
Excuse me, what about it?
You could recognise, could you not, member of the public looking at that, it's a coordination request, 11th of June 2015?
Looking at it, yes, I can.
Thank you. And it reads, Brussels, 11th of June 2015, Dear Mr. Vukcevic, coordination request, number, can't see the number, pursuant to the ongoing coordination between...
Objection, Your Honor.
You're in public session.
Yeah.
You just mentioned the name again. Do we ask you not to?
Yeah.
No.
You understand?
No, I've referred to Mr. Vukcevic,
Yes.
and there's been no direction in relation to Mr. Vukcevic. And indeed, the witness, Ms. Pumper, said there's nothing confidential about Mr. Vukcevic's name.
I would ask a clarification about which assertion of the witness the counsel is referring to.
If Ms. Bellucci wants me to provide a page and line in the draft transcript, I certainly can do with some time. Okay, have you got the line there?
We will redact the name, and please do not use it in public. You are referring to somebody who is a state official in another, and we do not want that name repeated in anything but private session.
Your Honour, this is the name of someone, as we clarified earlier in open session, was praised by the Chief Prosecutor of the Special Investigative Task Force on the 29th of July 2014 in a public press release for his assistance that he provided to the SITF.
Okay, let's go.
I mean,
Yeah.
confidentiality just becomes a tool for them to
Yeah,
play
but
with
not in relation to the specific document.
whenever it suits them.
Yeah.
Recorded.
Your Honor, if I may just clarify, there is no objection to mention in open session the specific name. There is objection in reading the contents of this document, which is still classified as confidential.
1208 in the transcript, in the live notes, Your Honour.
The objection is sustained. Go on.
So this publicly available document, which is on the internet for anyone to look at, reads, Brussels, 11th of June 2015, Dear Mr. I can't say the name. Coordination request number, we can't see that because it's covered by the U for the word in focus.
To object again, there has been a decision, if I may, Your Honor, in relation to the use of this trial as a way of further disseminating confidential information, and for the time being, this document is classified as confidential.
Yeah,
If it is confidential, you cannot read it in the courtroom.
I don't accept that it is, Your Honour. That's partly the purpose of this trial is because we do not accept that it is, and I am not publicly broadcasting this. Gazzetta in Focus is published by Halil Berisha, of which I make no criticism of them for doing so. I make that perfectly clear.
But now you are reading the confidential statement in court, and we will not allow it, and it's sustained, so go on.
I do not accept it's confidential. It doesn't claim to be confidential. We can look at the image. It does not claim to be confidential.
There's been a ruling that it is confidential.
Of that document, publicly available, published by Gazette and Newborn, can you see anywhere on there,
Mr. Rees,
a reference to it being confidential?
Mr. Rees, can I interrupt you? If you would like to go into this, we can go into private session so that you can ask this question, but it's not going to be asked in public session. We're giving you every opportunity to do that. We are just not going to publicize it.
Well, every opportunity, Your Honour, save for making a extempore ruling on the status of that document.
Do you want to go into private session?
No, but if that is the order of the court, then that is a matter for the court, and of course we will go into private session in the circumstances.
For purposes of maintaining the confidentiality of this document and the names contained therein in relation thereto, we will go into private session.
The claimed confidentiality of the document, Your Honour.
We had an open session, Your Honours.
We are back in open session. Court officer may escort the witness from the room. We will break for lunch. Everyone be back here at 2:30. I want to remind everybody to be careful to when you're off mic to turn your mic off, and I'm as guilty as some of the rest. And I know it's inadvertent, but it's important that we not be broadcasting our aside comments across the spectrum. So thank you. We'll see you at 2:30.
All rise. All rise.
Please be seated. Yes, Mr. Cadman.
Your Honour, I just had one question on scheduling for tomorrow. Can I assume that the court will not be sitting tomorrow afternoon due to the order that was passed yesterday?
We'll be in court through the first two.
Microphone, please.
Two sessions, but not the third session.
I'm grateful.
Before we bring the witness in, the panel wants to remind everyone of an official warning that it issued at the opening of the case on 7 October. It reads as follows. I'm quoting it. The material that the accused are said to have unlawfully publicized contain names and details of various individuals who are connected to investigations carried out by the SITF or SPO. Until that time when the panel determines whether that material was or still is confidential in nature, the parties are ordered not to make public reference to this information in public hearings. We therefore expect the parties to exercise due diligence in ensuring that the names and details of such individuals are not disclosed in public sessions, whether in their opening statements, questioning of witnesses, or submissions. If necessary, the parties should request private session if the name or function of any such individual is deemed material to a question they wish to ask or submissions they wish to make. And I indicated, please consider this an official warning. Parties are required and expected to abide by our orders and not to attempt to traverse them. We expect that greater attention will be paid in the future to the order just read out. Mr. Reese, that's what we were dealing with this morning in court, and I personally appreciate your enthusiasm, but I would ask you to please temper it just a bit, because you were wrong on your assertion. I know you'd like to have these names in public, but they're not going to be. And I ask you again, I don't ask you, I order you again to resist using those names. And now let's move on. You still have the floor, Mr. Reese. Oh, we need a witness. Okay. Please bring the witness in. Pardon me?
My enthusiasm to wait for the witness.
Your Honor, I just would like to note for the record that the Deputy Specialist Prosecutor is not attending this session.
I assume that you two have had some discussion during the noon hour. Am I correct with that? Ms. Bolizzi?
Nothing case-related.
Okay. Enthusiasm related.
Enthusiasm-related.
All right, thank you. Are you satisfied, Ms. Bolizzi, to proceed at this time?
Be raised in court, Your Honor.
All right, thank you very much. Ms. Pumper, you may be seated.
Thank you.
We will continue with your cross-examination. But this is the last session for today, and Mr. Reese will begin.
Thank you. Thank you.
When an individual's name is confidential, it does not follow that that individual's name cannot appear in any document, does it?
Your Honor is asking for the witness opinion, and there is an objection to that.
That is a very opinion-based question, and I believe you might want to rephrase it so it doesn't ask her for opinion or what she actually knows.
Would you expect, for example, that a individual whose name has been classified as confidential can, for example, have their name on a bank statement?
You mean confidential in like legal proceedings?
So I understand the need for clarification. Do you accept, do you, that the context is important and has a material effect on the use of a name, whether it's being classified as confidential or not?
Yes, I would agree with that statement.
So, for example, you agree that you would expect a witness whose name has been designated as confidential to nevertheless have his or her name on a bank statement?
I think that's unavoidable, that will take place.
Absolutely. On a driving license?
I assume so.
It may appear in a newspaper article?
Can do.
The witness is not stripped of his or her identity because of a designation of confidentiality. Do you agree with that?
No. Sorry, I agree with you that a person is not stripped of the identity.
Thank you. Paragraph 16 of your declaration, then, beginning 084015. At paragraph 16, you recount that you reviewed an article entitled Other Specialist Chambers Scandal. It cooperated with Serbia army officers who were also active during the time of Milosevic, published on gazettanewborn.co. When did you review that article?
Apologies, there is an objection to the reference to the title of the article as well in relation to the order that was mentioned by the presiding judge today.
Your objection's overruled.
When did you review that article, please?
I reviewed this article in due course of preparing this declaration.
The web page was GAZ.
Objection, Your Honor, for the same reasons as highlighted before.
Can we just have the, is there an ER and N number for this? These long web page, I'm not sure what your objection is, first of all. Let's deal with that. Which one I just did? Which one?
Is in relation to reading out the exact website address in open court.
Go ahead, Mr. Rees.
Thank you, John.
Thank you. I believe that, if I'm not mistaken, that there was a redaction order from this morning session for exactly the same kind of questions and statements from the Council, and this order has been notified.
Mr. Rees, what is the purpose of reading in this long website address?
Because I want the witness to confirm, if she can, that that web page, info, is still publicly available. An issue which we say is entirely relevant to the trial panel's consideration in the words that Your Honour reminded us at the outside of this session as to whether that page is or was or still is confidential.
Is that page, Mr. Court Officer, does it have an ERN number?
I'll refer to the ERN in the next question.
Well, okay. I think she could have answered the question either way without reciting that long number. I'll overrule your objection. You can answer it, if you know.
I don't recall this path. what you just read out?
The image of the page is at ERN 081915. Oh 81916.
For the purposes of the record, Your Honor, that is P 124.
Already admitted?
So if you can, please.
Excuse me, just a second, Mr. Reese. Mr. Court Officer, is that admitted as P?
Yes, Your Honor.
All right, go ahead.
So if we can fit to height, please, Mr. Court Officer. Thank you. Do you recognise, that's the first page of the article, do you recognise that?
I do.
And if we just look quickly at the second page. And we can see an image. It's got the SITF logo in the top left corner, yes?
Yes.
And if we can go to the English translation, please, now at 081915-081916-ET. So if we can go down to page 81915, please. So if you Mr. Court Officer, if you go back to the English translation and do fit to page. So the fit to page logo is the little box, that's it. Thank you. And we can see at the bottom there, we've got the reference 081915. Yes? Yep. So if we can go back to fit to page, please. Thank you. Thank you. So the article that you reviewed, we've already read the title. The first paragraph reads, other documents speak of the cooperation the specialist chambers had with Serb officers who were in active duty during the time of the Butcher of Balkans, Slobodan Milosevic, and in accordance with the trial panel's ruling, we will now need to go into private session. I wish to read the article into the record.
I'm sorry. In order to protect the other names in the document, we will go into private session. Mr. Rees, you handle this as you wish, but that's an admitted exhibit. You merely could have asked her to read the names and not have to announce them.
Of course, I've considered that. The fact is that it will become very difficult to continue with cross-examination when we're dealing with, we don't even have pseudonyms to refer to.
Go ahead. Go ahead.
We are in open session, Your Honours.
Thank you.
Are two names of Serb officers who were present in some of the macabre massacres committed in Kosovo by the Milosevic regime. Newborn newspaper obtained the document showing that these Serb officers were contacted by the specialist chambers in order to give testimony against KLA and its members. In the final paragraph of the article, it said that the Specialist Prosecution Office Deputy Prosecutor Kwai Hong, after thousands of files, which according to reports contained, among other things, names of witnesses and their testimonies, fell in the hands of KLA veterans. Firstly, can you help us? You may not be able to, but can you help us with whether that is accurate, that Kwai Hong Ip did resign in the wake of the leak?
Objection, Your Honor. It's irrelevant to the testimony that the witness gave on the examination in chief. It's not clear what's the purpose of what's the relevance of the counsel question.
It's remotely relevant, and I'll allow it and continue.
Thank you.
I'm sorry, I will allow it as a relevant article. All right, go ahead.
So can you confirm that Kwai Hong Ip did resign in the wake of the leaks in September of 2020?
I am not privy to the reasons of him resigning from our organization.
That was the next question. Can you confirm that he did resign in the wake of the leaks in September 2020?
This is what is my information, yes.
Thank you.
Sorry, if I can go back. In the wake of September 2020, I would not confirm that. I would just confirm that I know that he resigned, that I was told he resigned, but not in the wake of something.
I understand.
Thank you.
And I do too. So thank you for the clarification. Do you know when he resigned?
I don't remember when, but I know it was from a timeline before.
Shortly after September 2020?
Sorry, I believe before September, before the leaks.
Well, no doubt that can be clarified. I am going to ask you to look at another document before I ask some more questions about the persons you've just seen. Okay? The two names we read in private session?
Yes, yes.
So, please can we look at 080464-080464. So this document purports to be a coordination request that is addressed to a Serbian official, and it has a facsimile of the signature of Kwai Hong Ip at the bottom, yes?
Correct.
And there are 3 names mentioned in the body of the text. And I will ask, pursuant to the order of the trial panel, that we go into private session at this stage.
For purposes of protecting the names in the document, we will go into private session.
Can I make it clear? I understand
We are in public session, Your Honours.
Thank you. Go ahead, Mr. Rees.
Thank you, Your Honour. This is another article that you reviewed. Do you recognise it?
Yes, I do.
And referring to the English translation, the headline is "Scandalous. The specialist chambers collaborated even with Serb MUP, Ministry of the Interior, to arrange witnesses to testify against KLA." It continued, "New evidence shows about a scandalous process carried out by the specialist chambers regarding its accused people who are KLA members. The document found by Gazeta Newborn shows that this court has cooperated with Serbia's MUP in order to secure and find as many witnesses as possible against those accused who are KLA members. The Serb MUP, what is the Serb MUP, please?
MUP stands for the Serbian police.
And the Ministry of the Interior in Serbia, what is that?
Ministry za utornane poslove, I believe, something to that effect.
And again, it's clear, is it not, that the publishers of Gazeta Newborn, it is Gazeta Newborn that published this article on the internet, is it not? You can see from the exhibits, it's Gazeta Newborn who
Yeah,
published
if you would
this.
just please give me a bit of time just to have a look at it.
I apologise.
I can see, yes, at the left side that there is a link to gazetanewborn.co.
Yeah. So it's clear, is it not, that Gazeta Newborn was of the opinion and made it public that it regarded it as scandalous that the specialist chambers had collaborated even with Serb MUP, the Ministry of the Interior, to arrange witnesses to testify against the KLA, yes?
Objection, Your Honor. She can't testify anything more than what is written in the article about that.
And that web page is still publicly available, is it not?
I do not know.
Can we look at another article that you reviewed and you refer to in your evidence, 081917 to 081919? And again, can we have the English translation alongside it, which is at a slightly different reference, 081917 081918 ET. If you look at the printout from the web page itself first, you can see in the top right hand corner there is a web page, web address.
Yes, I can.
It's cut off, so we can't see the full address on the webpage, but it's right, isn't it, that as you explained earlier, and a colleague of yours at the SPO actually did the task of identifying these web pages and then printing off copies of the web page. Yes? Another colleague did that, not you,
For the purpose of these hearings,
for the purpose of the investigation. Another colleague went through the internet and identified websites and printed them off.
yes, in this article I did the same steps and repeated what he has done.
And that, the other colleague, he wrote out in full, didn't he, the web pages that he visited to find these articles.
Yes, he cut and pasted them.
So I could, for continuity purposes, go through the web page in full, but I've been asked not to. But this is a document that also is still available on the internet, publicly, in full. Do you know or not?
I do not know.
We look at the English translation now, and again, although I do not agree that these persons require protection, in accordance with the trial panel's ruling, I will ask to go into private session so that I can read the article in full.
Private session, Mr. Court Officer.
We are in public session, Your Honors.
Thank you, Mr. Court Officer. Go ahead, Mr. Rees.
Thank you, Your Honor. You are not... So for the evidence screen, can we look at, please, paragraph 19 of the declaration? Thank you. Page 18. 084018. Thank you. Thank you. So paragraph 19 there, you can confirm, can you not, that you were not present at the seizure of any documents at the KLA WVA on the 17th of September 2020?
I can confirm I was not present.
You have, in your direct examination, referred to a document of that date, which is at ERN 079500. This document, thank you. This document is headed delivery document. It is dated the 17th of September 2020. And there is an ERN number at the top right, but it is right, isn't it, that that ERN number would not have been stamped on the document at the time of attendance upon the WVA that day.
That is correct.
So that was applied sometime after. Same question as I asked previously for the earlier delivery document. Do you know when that stamp would have been applied?
I cannot recall the exact date. But it would have been applied at the submission into Xylab.
Yeah, whenever that was after the attendance upon the WVA.
Correct.
The reference simply has a KSC case number, yes, which was a slight difference to the original, the delivery document for the 8th of September, yes. That document we looked at earlier, we don't need to turn it up, I don't think, simply read documents delivered to KLA WVA. This document reads KSC-BC-2018-01, yes?
That is correct.
And then we have an entry in handwriting in the row marked content. Documents brought to WVA by unknown man, 16.9.2020.
Keep your pace a little slower, Mr. Rees.
Thank you for the reminder, Your Honor. I do appreciate it. The delivery document gives us no further description or detail as to the content of the documents. Do you agree?
I agree.
It doesn't give us the number of documents seized.
It does not.
Or the content of the documents seized.
Not in addition to what is described under the column content.
Yeah. And it doesn't, for example, give us the number of any evidence bag.
It does not.
So, if the documents that were seized were put in an evidence bag, we don't know from this document what evidence bag it was.
Not from this document, correct.
You may or may not be able to help with the next set of questions. Please say if you cannot. But you'll appreciate I ask you because the SPO only intend to call evidence from yourself and from one other SPO officer. So I have little choice. When the press conference on the 7th of September took place, 2020, and in the days afterwards, it was made perfectly clear publicly, was it not, that there was at least the potential for further documents of a similar nature to be delivered to the KLA War Veterans Association.
I have read that in transcripts of press conferences.
Thank you. If the documents that you label as batch 1 contained, as you assert, genuinely confidential, sensitive material, the SPO, one can presume, would have wished to have stopped any further release of a similar nature. Do you agree with that?
I had no involvement in any activity prior to the 25th of September, and I have very limited knowledge of that.
Again, I thank you for your candour over that. I asked the question. If you don't know, as you've just done, please say. You weren't asked to conduct any surveillance of the KLA War Veterans Association headquarters between the 7th of September and the 17th of September 2020?
I have not been asked.
You are an experienced investigation coordinator, are you not?
I have 20 years of experience
Yeah,
in investigations.
absolutely. So I understand you're saying you weren't asked to undertake any surveillance, but can you help us as an experienced investigations coordinator, 20 years experience of investigations, if you were tasked from the 7th of September.
Objection, Your Honor, it's hypothetical from the start.
I'm sorry, I don't have any idea what you just said.
The question is hypothetical. It's asking what the witness would have done if she were tasked. She explained that she was not tasked.
Let's wait till he finishes his question. Go ahead, Mr. Reese. And then, ma'am, don't answer.
Microphone, please.
The attorney for the prosecution can make herself known.
Thank you.
And of course, if you regard it, because it's a hypothetical question, as one you cannot answer, you will no doubt explain that. You are, after all, an experienced investigator. You have 20 years of experience, and no doubt you've given evidence in court before. Have you?
I have given evidence before in court.
Many times?
Not many times.
Enough times to be able to answer for yourself, have you not?
I'm not sure what you mean with that.
Well, let me revert back to the question. If you had been asked on the 7th of September to coordinate the investigation, having seen, as you've conceded now, that there was no secret that there may well be at least a potential for further documents to be delivered to the KLAWVA headquarters, would it have occurred to you to, for example, place the headquarters and its environs under surveillance so that you could stop any such delivery?
There is an objection to that. The question is beyond the scope of the direct examination, is speculative, and ask for the witness' opinion on this matter.
I'm sorry. You may answer if you wish, if you have an answer.
Had I been assigned the task to coordinate this, I would have considered any option, most likely including, if feasible, a surveillance, if feasible.
So,
Consider.
you weren't asked to undertake surveillance, but are you aware if anybody was?
As I said before, I am not. I had no involvement and very limited knowledge.
And are you aware if anybody took the decision deliberately not to put the headquarters under surveillance?
I have no knowledge of that.
Who would have knowledge of that?
The persons who would have knowledge of that is only the specialist prosecutor and the deputy specialist prosecutor.
So, the decision as to whether to place the headquarters under surveillance or not would have been taken at the very highest level. But you don't know whether any such decision was taken and what the decision was.
Your Honor, will you allow me to clarify something?
Yes, you may.
Counsel, you have, or Your Honor, you have asked me yesterday to find out a couple of questions which you had. And I was told yesterday that the overall coordination and management of this investigation was conducted by the specialist prosecutor and by the deputy specialist prosecutor. And from that information, I derive that the decision whether to surveil or not surveil would have been taken by the two. But I was not specifically told or not told.
You're aware now, are you not, that the delivery of batch 2, as to be referred to, I accept conveniently for shorthand, was observed and indeed recorded. But it was recorded by a journalist and a cameraman from the media outlet Arbrecht Info. Are you aware of that now?
I have read that in an official note which I reviewed as part of writing my declaration.
And seen it because it was videoed, was it not?
I am sorry, but at the point I cannot recall whether I've seen it. It is possible that I've seen it.
And of course, the journalist and the cameraman quite understandably made no attempt to stop the person. But if the property was under surveillance by SPO officers, and they saw the same thing as the journalist and cameraman, is it a proper inference that one can draw that they must have allowed the delivery to take place?
Your Honor, the question is speculative.
Sustained.
Again, assist us if you can. If you cannot, please tell us. You don't know the answer. Are you aware if any attempt was made to contact the journalist and the cameraman after they broadcast the video of the delivery taking place?
I don't remember.
You are aware as well, are you not, that a car index number related to the person dropping off documents, making the delivery, was recorded and provided to SPO officers?
Is that a question, Mr.
It is a
Rees?
question. I'm asking if she's aware of that.
I am aware of that.
Bear with me for a moment. The registration provided on the 16th of September by, sorry, on the 17th of September by Mr. Gucati to the Can we pull up the document 089049 red? And perhaps if we just leave it at that scale for the moment. Remembering that, as we saw earlier, Mr. Gucati was raising at the outset, was he not? Questions such as the authenticity of the documents, where they'd come from, and inviting investigation into those matters, yes?
I read that in the transcript, that is correct.
And provided the vehicle registration plate on the 17th of September 2020 to an SPO officer. This is the check on that registration plate. If we can put fit to height, please. Can you see that number plate there, just towards the bottom of the pages? In fact, it's Can you see that?
Your Honor, if I may, I'm asking whether it's necessary to state the plate number in open session for privacy reasons.
Well, it's been stated quite a few times already, and I don't know if there's any reason not to. At this point, it's been stated several times. Go ahead.
Well, if the witness can remember the number, I won't mention it again.
Okay.
But you can see the number that I read out in the middle of the text, paragraph to the bottom as we can see it on the screen, and it looks like there was a request for information about that on either the 25th or the 26th of November 2020. Do you agree?
I've never seen this document, but
No.
from the document I would agree.
Thank you. And we can see the date of the document, if we fit to screen, please, at the top, 27th of November 2020. Yes?
Yes, correct.
Oh, again, please say if you cannot help us. But is there any explanation why, when that number plate was given to the SPO on the 17th of September, the day after it was observed being involved in the delivery, that no check was done on that until the end of November?
I cannot answer that. I have no knowledge of that.
Because again, after the second delivery to the KLAWVA headquarters, it was perfectly clear, wasn't it, that there was a chance at least, more than that I'd say, but a chance at least that there might be another delivery of similar documents, yes?
Or
I'll
are
rephrase
you
it.
asking a question?
I'll rephrase it. Did you consider, I'll rephrase it, do you consider from the material that you have seen now and read that there was at least a possibility that there would be another delivery of documents to the KLAWVA after the 16th of September?
I cannot recall what exactly was said in the first press conference, but I would say if Mr. Haradinaj specifically mentioned that, yes, there was a likelihood it could happen. That would be my opinion.
Well, the trial panel in due course will see lots of references where that potential was raised. No secret made about it. It was raised with requests to the SPO to investigate who was doing it. So, as an experienced investigator of 20 years, if you put yourself in the shoes of an officer given that number plate on the 17th of September, would you expect to have conducted a more expeditious inquiry into that number plate and who was driving it than waiting until the end of November to do it?
Objection. Objection. It's speculative and is asking for the witness' opinion on this matter.
Overruled. I'll allow you to answer the question.
Your Honor, as I said earlier, had I been in charge of this investigation, I would have considered every option possible with the resources that I had at hand, and that could have included making a request at an earlier stage.
But you weren't asked to conduct inquiries at this stage, and you cannot give us an explanation as to why no check was done on that number plate until the end of November. Is that right?
As I said, I was not involved, not informed. I can't give an explanation because I don't have the information.
Yes. I haven't quite finished with this topic, but it will take longer than, well, it will take us past 4 p.m., so I'm in your honest hands.
How long? I'll hold you to it.
Could be 15 minutes. Could I, Your Honour, could I request that I finish this topic first thing in the morning?
Not limiting you. I just want to know for Mr. Cadman and for the prosecutor, how much longer with this particular witness other than the 15 minutes? Just an estimate.
So, I certainly do not anticipate being finished with the witness tomorrow. I am conscious that there is a hearing in the afternoon tomorrow, and trying to be careful about it. I anticipate at the time we adjourn with this witness tomorrow, there may be substantial cross-examination left to continue with at the beginning of next week.
We'll let you go ahead and we'll honor your
Thank you.
Microphone, please.
Allow you to finish up with this witness in the morning. Mr. Cadman, you'll just have to be patient and wait.
Well, Your Honour, all I would say is at the outset, when Your Honour's requested scheduling, it was made quite clear that I would not be repeating anything.
Yes,
Mr. Rees
so I
has
assume
covered.
yours will be considerably shorter.
Well, I can't say how long I'll be.
Oh.
That will be judged at the end of Mr. Rees's cross-examination. But certainly we have taken the position that many of these matters affect both defendants in the same way.
They do. Okay, so we will, if you will escort the witness out, please. Sorry, Ms. Polizzi.
No problem, Your Honor. Thank you.
Wait, can we
Yes,
excuse the
I will
witness
wait,
first?
yeah.
All right, Ms. Polizzi.
Your Honor, two brief points. One is that there were questions today from counsel suggesting that Mr. Kwai Hong resigned after the disclosures at the KLA World Veteran Association in September 2020. And I would like to state for the record that, as previously mentioned that by the SPO spokesperson, Mr. Kwai Ip Hong left the SPO for another opportunity in August 2020. And the second matter is entirely practical. For scheduling purposes, it would be helpful for the SPO to have a time estimate of the time necessary for concluding the cross-examination in order to plan the next witness's examination. Yeah, so early next week, it makes a difference between being able to conclude our witnesses next week or not.
Well, we're going to really hope that you can, so we're planning on that.
Yeah.
And I do understand that the trial panel is planning on that, and we will do our best to reach that position. But if the SPO are asking for our assistance in the organisation of their witnesses, for my part, I think it is unlikely that we would reach the third witness who was added to the witness list most recently. Of course, things can change and things can go quicker, and I hope they do. But that is, if it is of any assistance, that is our estimate as to how things will
Well, and
progress.
everyone is aware of the fact that we are having a ex parte hearing on Thursday that could also change the complexion
Indeed.
somewhat of what's
Absolutely, which is what I was trying to be careful about earlier when you're on.
going on. I understand. Okay, well, so tomorrow, 9:30, we'll see you at that time.
All rise. Sorry, really.